Good morning. I'm Gary DeWall, and this is Bridging the Week for August 5th through 9th, and today is August 12th, 2019. Last week, a Canadian-based social media company answered charges filed by the Securities and Exchange Commission in June 2019 that its 2017 offering of digital tokens constituted an unlawful securities offering under United States securities laws. The company argued that its digital tokens were not securities, but were more akin to virtual currency like Bitcoin. In any case, said the company, the SEC never provided it with adequate notice regarding what crypto assets it might consider to be securities. This is my first taping ever of Bridging the Week from outside New York City. Today, I am in the foothills of Rocky Mountain National Park in beautiful Estes Park, Colorado. So I can get outside and do a little hiking. Let's get started. Kik Interactive denied it conducted an unregistered security offering in answering the June 2019 complaint filed against it by the Securities and Exchange Commission. In its complaint, the SEC claimed that from May through September 2017, Kik conducted an initial coin offering of 1 trillion KIN digital tokens without registering the crypto assets with the SEC as required by law. According to the SEC, investors who purchased KIN tokens made an investment of money in a common enterprise with Kik and with other investors and reasonably expected profits through the business and management activities of the company and its agents. The SEC alleged that through its KIN offering, Kik raised almost $100 million US, including more than $55 million US from US investors. In its answer, Kik denied that its KIN token was an investment contract, but instead was a non-security digital token of the nature of a quote-unquote community currency more akin to Bitcoin. Kik claimed that the SEC based its allegations on quotes taken out of context and documents and testimony provided to the SEC that the SEC also misrepresented. Additionally, Kik claimed that the SEC wrongly conflated its pre-token distribution event token sale to accredited investors in the United States and its token distribution event to retail and non-retail persons as a single unlawful event. By the way, for Kik, token distribution event is the same as an initial coin offering. Kik's answer provided extensive, specific examples purportedly supporting its claim that the SEC selectively used or misrepresented quotes, documents, and testimony, as well as numerous legal arguments as to why KIN tokens were not investment contracts. Principally, Kik argued that it consistently noted that KIN's success would, quote, involve the efforts of users and content providers other than Kik, end of quote, and that the price of KIN would depend on ordinary forces of supply and demand and not from Kik's efforts. Additionally, Kik posited that even if the SEC now believes that KIN tokens are investment contracts and thus securities, a prosecution based on such a view violates its due process. This is because prior to the token distribution event, the SEC never provided sufficient guidance for Kik to understand that the sale of KIN in its token distribution event would violate relevant law. Kik also claimed that its token distribution event pre-sale to U.S. accredited investors was authorized by applicable SEC rule and was a distinct event from the token distribution event. As a result, it said it should receive judgment in its favor, at least as to that portion of the SEC's complaint. Both the SEC and Kik have diametrically different views regarding the circumstances that led to the issuance of KIN, both during its pre-token distribution event fundraise and during its token distribution event itself. In its answer, Kik requested that triable facts be heard by a jury, and it may likely be that a jury determines the outcome of the SEC's enforcement action if it is not resolved earlier through motion practice or settlement. However, Kik makes a compelling argument regarding the lack of concrete guidance from the SEC regarding its view of the types of crypto assets whose offer or sale could lead to an SEC enforcement action for violating registration requirements. Kik argues that its prosecution by the SEC without concrete advance guidance deprives it of due process. This is an argument that will likely be addressed further through motion practice. For more of my views on this, check out the article version of Bridging the Week at www.bridgingtheweek.com. Well, that's it for this week's vision of Bridging the Week. As always, there's more articles and commentary on the article version of Bridging the Week at, I just said it, www.bridgingtheweek.com. Check it out. I'm Gary DeWall, and until the next edition of Bridging the Week, have a great week, and ciao.